Yep.
Good afternoon and hello, everyone. Welcome to the Office of Tax Appeals. Today's oral hearing and proceedings for the appeal of Stephen Eichler will be live streamed. The stenographer will translate everything that is said. I am Shreen Ridenour and will be the lead administrative law judge for purposes of this hearing. My co-panelists today are Suzanne Brown and Josh Lambert. Also present is our stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Also, speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing, Ms. Alonso will produce the official transcript, which will be available on the Office of Tax Appeals website. Thank you, Ms. Alonso. Before we go on the record, I just want to discuss a couple of things. The Office of Tax Appeals is not a court, but is an independent appeals body. The office is staffed by tax experts and is independent of California's tax agencies. Please say your name before you speak. This is especially important because some participants may only have an audio connection. And also, this is the reason why the Webex feature is disabled. Please mute your microphone if you're not speaking to avoid feedback and background noise. A reminder that these proceedings are being broadcast live and any information shared on the screen is publicly viewable. In addition, while this office is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record on which a decision may be based and to conduct an orderly hearing. Both parties must be courteous to each other and to the administrative law judge panel, and neither party may interrupt the other party. Each side will have the opportunity to be heard, so please wait for it when it's your turn to present your side. Also, I may interrupt the hearing if we get out of order or become counterproductive. This is not necessarily because anyone is doing anything wrong. Rather, keeping us on track and creating a clean and efficient hearing record is part of my role as lead administrative law judge. Finally, as a preliminary matter, Mr. Eichler, you mentioned during the pre-hearing conference that you would decide today if you were going to be testifying. Have you decided if you'll be testifying today?
Excuse me, Stephen Eichler. Well, based on both yours and Judge Kui, I believe his name was, explanation, I think my belief and understanding is that the only way to really, how do I say this, be heard is probably to allow myself to testify as opposed to just simply being the appellate. I think that's the right word.
Representative of yourself. Okay, perfect.
Okay.
So
yeah.
When we go on the record, before I will swear you in.
Very good.
And also, just to remind you, this also means that FTB may ask you questions as a witness.
Fair enough.
Okay, thank you. Did either party, pending a showing of good cause, intend to submit additional exhibits previously not submitted or call any witnesses previously not named? Mr. Eichler? Did you?
I do not. I do not.
Daniels?
No, we do not plan to.
Sounds good.
May I ask one question? I'm sorry.
Actually, by all means, that was my follow-up. Any questions or anything you have before we continue? So yes.
Forgive me too. I'm in a fog. My plane landed at 4:30 a.m. So it's already a crazy day. But having said that, Miss Daniels and I'm looking at the participant list because I'm trying to remember names, and another person were on our pre-hearing call.
Right.
And now there are two, I believe there are two additional people attending from Cdtfa.
Correct.
And I'm just wondering what their role is and how does that fit within your question about other people being involved in the hearing?
So Ms. Bergen, when she was at the pre-hearing conference, she did indicate she was there for Mr. Smith because he was unavailable. So she was in as a temporary. And so.
Okay, thank you.
Yeah. So that answer your question?
Well, there's another person now, I think, also.
Mr. Parker is also here because it's an underlying 6029 liability, I believe. And so he is here to answer any questions for underlying liability. Would that be correct, Mr. Parker?
Yeah, this is Mr. Parker. That's correct.
Okay, I'm not sure what the numbers mean, but I accept the answer. Thank you.
Of course. And if you ever have any questions, please, if someone else is talking, just raise your hand, and I am
Okay,
willing to answer any questions and get this. Okay, so.
okay, thank you.
All right, of course. Cdtfa, do you have any questions before we proceed?
No, we do not at this time. Thank you.
All right. Judge Lambert, are you ready to proceed?
Yes.
Judge Brown, are you ready to proceed?
This is Judge Brown. Yes, I am. Thank you.
All right. And Ms. Alonzo, are you ready to go on the record? All right. I get a thumbs up. So we are opening the record in the Office of Appeals oral hearing for the appeal of Stephen Eichler, OTA case number 180-32551. Today's date is Wednesday, August 21st, 2001, and the time is 1:10 p.m. This hearing is being conducted electronically with agreement of the parties. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Shreen Ridenour, and I am the lead judge. Judge Suzanne Brown and Josh Lambert are the other members of this tax appeals panel. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. For the record, will the parties please state your names and who you represent, starting with the representatives for Cdtfa.
This is Courtney Daniels representing the Department of Cdtfa. Thanks.
This is Stephen Smith with Cdtfa.
And this is Jason Parker with Cdtfa.
And Mr. Eichler, please introduce yourself.
Sir, Stephen Eichler, representing myself.
This is Judge Ridenour. Thank you. As discussed and agreed upon by the parties at a pre-hearing conference on August 4th, 2001, and as stated in my minutes and orders dated August 5th, 2001, there are 3 issues in this appeal. They are whether appellant is personally liable under Revenue and Taxation Code Section 6829 for Housewise LLC's unpaid sales and use tax liabilities for the liability period of July 1st, 2008 through June 30th, 2009, whether relief of the penalties asserted up against Housewise is warranted, and whether relief of interest is warranted. In addition, the following facts are agreed upon by the parties. Housewise ceased to occupy his Menlo Park offices and showroom at the end of February 2009 and made his final sales of tangible personal property during the 3rd quarter of 2009. Appellant filed Housewise returns for 1st quarter of 2008, 2nd quarter of 2008, 1st quarter of 2009, 2nd quarter of 2009, and 3rd quarter of 2009. Appellant knew Housewise filed its 1st quarter of 2009 and 2nd quarter of 2009 without remittance. Housewise failed to file timely returns for 3rd quarter of 2008 and 4th quarter of 2008. At all times, Mr. Eichler was a managing member of Housewise who had the responsibility for filing of returns and the payment of tax for Housewise. Specifically, as to the elements for personal liability under Revenue and Taxation Code 6829, the following has been agreed. Housewise business terminated during 3rd quarter of 2009. Housewise collected sales tax reimbursement on its sales of tangible personal property during the audit period. Appellant was the person responsible for Housewise sales and use tax compliance during the audit period. As such, of the 4 elements required for personal liability under Revenue and Taxation Code 6829, the remaining element in dispute is whether appellant willfully failed to pay taxes due from Housewise or willfully failed to cause such taxes to be paid during the liability period. And as for exhibits, each party's exhibits were listed in the exhibit log, which was attached to the minutes and orders, as well as copies emailed to the parties after the pre-hearing conference. During the pre-hearing conference, neither party raised objections to the other party's exhibits. As such, pursuant to my minutes and orders, appellant's exhibits 1 through 5 were admitted into the record, and Cdtfa's exhibits A through D were admitted into the record. After issuance of the minutes and orders, in response to appellant's request for relief from penalties and interest, Cdtfa, by response dated August 20th, 2021, agreed to remove the finality penalty, thus leaving the failure to file penalties for 3rd quarter of 2008, 4th quarter of 2008, and the late payment penalties for 1st quarter of 2009 and 2nd quarter of 2009 at issue. Mr. Eichler indicated that he will be testifying today. As such, he will be sworn in before his representation. There are no other witnesses today. As a reminder to the parties, during our pre-hearing conference, we decided that the parties will each have 15 minutes to make their arguments, starting with Mr. Eichler. Then Mr. Eichler will have 5 minutes to provide a closing argument if he chooses. Does anyone have any questions today before we move on to the presentations? Mr. Eichler?
I do not, thank you.
Ms. Daniel, Cdtfa, this is Judge Reitauer. CDTFA.
No questions at this time.
Okay, great. This is Judge Reitauer. We are ready to proceed with Mr. Eichler's presentation. However, first I need to take your oath so that we may consider your statements as testimony, and you will remain under oath until the closing of this hearing. Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
This is Judge Reitauer. Thank you. When you're ready, Mr. Eichler, please begin your presentation.
Okay. Should I be saying my name before every time I speak, or how would you like that
No.
done?
This is your presentation, so this is your whole time. Just go ahead and just
Okay.
thank you for clarifying.
Okay. I did watch some videos, so I did see people do that every single time. Anyway, as I said, I apologize. It's been a crazy day already. I think what I'd like to do in this presentation is, given what Judge Rittenhauer, and we all have really agreed, is that mistakes happened. I don't think anybody's in disagreement about that. And hindsight is wonderful in that manner to see that. And I think that because of that, and because of the fact that I believe that I am a very honest person and have a lot of integrity, why I went the way I did was to try to come up with a settlement approach. Now, I will say and admit, I understand from our pre-hearing conference that the settlement agreement that I did sign in and of itself is not necessarily admissible, or whatever the right word is for this particular hearing, other than I would like to reference to it as an example of me trying to solve a problem and trying to work with the situation as best as I possibly could to try to rectify it. And therefore, I think that where I wish to spend my time in this 15 minutes, and most likely less, is just to hopefully express, demonstrate, present the fact that nothing that occurred was deliberate, was willful. There was no money that went into my hands whatsoever, or distributed to me in any manner whatsoever. I did not benefit in any way from the events. The mistakes or errors, excuse me, again, were not deliberate or willful. And I've tried to do the right thing, whatever that pretends to be. The economic stress and duress and financial duress that occurred in 2008 out of this calamity, which is one that I wish I could completely erase from my world and never have happened, was just unbearable, absolutely unbearable. And it's in all the documents. I'm not going to belabor it. It's like going through PTSD. I lost a home. I went bankrupt. I went broke. I mean, it was just the worst of all of calamities that I think anyone should ever go through. If you look at it, and again, I understand the boundaries of the hearing, but if one were to look back at my relationship with what was then the State Board of Equalization, my returns for this business, or the one that we're talking about, for ones prior, for ones after, wherever that role existed, has always been stellar. Of course, I never had the experience of going through the financial calamity that I went through in 2008, 2009, and frankly, well into 2015 and even to today. That was just off the charts. And I know we all know that just from history. Again, to come back to the fact, I tried to settle, I tried to do something where I could come up with an answer, a solution, a resolution that we could all work with. And by we all at that time, it was the State Board of Equalization, which then became a very much longer name, and which we abbreviate now to Cdtfa. You know, I tried. I really did. I went through a handful of people, but that economic and financial duress continued. I mean, I can give you examples of conversations that I had with representatives of the Cdtfa who would say things to me like, and I quote, I wrote this down in 2016, that her manager looked at my address and assumes that it is a $3 million home. So there's no reason to settle. And I'm like, first of all, it wasn't my home. And second of all, if anybody knows how to use Zillow or any of the technological tools, and obviously if we could turn the clock backwards, would know that there is no way in heck that the home that I lived in was a $3 million home. But at the end of the day also was, what bearing did that necessarily, I mean, I understand, I should be careful. I understand the optics, but that's not something that she should have been telling me, I don't think. I mean, that to me was just unnecessary economic and financial duress, in my view. Even to this day, I don't have the financial resources to pay, you know, to pay the kind of numbers that you all are talking about. I want to do something. Again, I realize this is my testimony. I want to do something. I want to make amends. That's just who I am. But I did not go out in any deliberate manner and say, hey, I'm just not going to pay this, guys, and I'm going to go buy something or do something or save my house from foreclosure, which was completely impossible to do anyway. Even having reached out to our then attorney general, who is now in a much better office. You know, I tried so many different things to solve problems, and it was the financial and economic duress and depth of this was just insurmountable, completely insurmountable. I think that's all I want to say. I want to be respectful of all your time, and I don't want to go on and probably say the same thing over and over. And I'll stop there. Thank you.
This is Judge Ridenour. Thank you, Mr. Eichler. Cdtfa, do you have any witnesses for Mr. Eichler as a witness?
We don't have any questions for Mr. Eichler at this time.
Thank you. This is Judge Ridenour. Judge Brown, do you have any questions?
This is Judge Brown. I don't have any questions at this time.
This is Judge Ridenour. Judge Lambert, do you have any questions?
This is Judge Lambert. No questions at this time. Thanks.
This is Judge Ridenour. I also do not have any questions at this time. Thank you, Mr. Eichler.
Thank you.
Cdtfa, when you're ready, Ms. Daniels, you may please begin your presentation.
All right, this is Courtney Daniels. Good afternoon, everyone. Appellant's unpaid liabilities at issue originate from a notice of determination that was dated June 18th, 2010, which was issued to Housewise, hereinafter referred to as the company, for the third and fourth quarters of 2008, which the company failed to file returns for, and for filed non-remittance returns for the first and second quarters of 2009. As you're aware, 4 elements must be met for personal liability to attach under Section 6829 of the Revenue and Taxation Code. First, the corporation must be terminated. Second, the corporation must have collected sales tax reimbursement. Third, the person must have been responsible for the payment of sales and use tax. And fourth, the person's failure to pay must have been willful. As appellant has conceded the first 3 elements, our presentation will only focus on the last element, which is willfulness. The evidence establishes that appellant's failure to pay the company's tax liabilities was willful. Per Regulation 1702.5, Subdivision B2, willfulness means a voluntary, conscious, and intentional course of action, but it does not require bad purpose or a motive. A responsible person willfully fails to pay taxes if the department can establish that the responsible person had, first, actual knowledge that the taxes were due but not being paid. Second, authority to pay the taxes or cause them to be paid when the taxes became due and when the responsible person had actual knowledge that the taxes were due. And third, the ability to pay the taxes but chose not to do so. We will address each element in turn. So the first requirement is knowledge, which means the person knew the taxes were not being paid on or after the date that the taxes came due. Appellant has conceded that he filed the company's returns for the first and second quarters of 2009, which are provided at Exhibit C2, pages 1 through 4. Appellant also conceded that he filed returns for the first and second quarters of 2008 and the third quarter of 2009. See Exhibit D, pages 39 through 47. Additionally, appellant stated that he was aware that the first and second 2009 quarter returns were filed without remittance. Therefore, appellant clearly knew the taxes were due but not paid for the first and second quarters of 2009. As to the remaining quarters at issue, the third and fourth quarters of 2008, for which no returns were filed and no taxes paid, there's no dispute that appellant was the person responsible for ensuring the company's filing of quarterly returns at such time. Appellant affirmed this in his own statements to the department, which are memorialized in the ACMS entry dated September 24th, 2008, at Exhibit A, page 13, where he told the department, or sorry, Exhibit D, page 13, where he told the department staff during a telephone conversation that he was the sole person responsible for running the business. In light of this ACMS entry, as well as appellant's history of active involvement in the filing of the company's tax returns, it is highly unlikely that the appellant was unaware that the company had unpaid taxes for the third and fourth quarters of 2008 at the time that he failed to file those two returns. As to the second element, authority, the responsible person must have authority to pay the taxes or cause them to be paid on the date the taxes became due and when the responsible person had actual knowledge the taxes were due but not paid. Appellant has conceded that he had authority to pay the company's sales tax liabilities throughout the liability period, which is documented within the agreed facts portion of this court's minutes of the pre-hearing conference. His authority is also apparent given his past payments of the company's tax liabilities and his statement that he was the sole person responsible for running the business, again at Exhibit D, page 13. As to the final requirement for willfulness, the responsible person must have had the ability to pay the taxes but chose not to do so at the time that the responsible person had actual knowledge taxes were due. Appellant had sufficient funds available to pay the taxes when they became due, but chose not to. Records from the company's suppliers show that the company made payments to the following suppliers during that liability period. First, the company paid Riggs a total of $8,000, and that was between February 3rd, 2009 and March 13th, 2009. And those documents are available at Exhibit D, pages 176 through 184. Second, the company paid Decorative Plumbing approximately $43,112, and that those payments were made between August 12th, 2008 and May 13th, 2009. And those documents are available at Exhibit D, pages 72 through 74. Finally, it made payments to a company called Hyoka, totaling approximately $13,801, and that was from August 20th, 2008 through March 20th, 2009. And you can see Exhibit D, pages 185 through 193 for that documentation. Additionally, there is no dispute that during the liability period, the company collected tax reimbursement from its customers on its taxable sales of tangible personal property. And therefore, the company had those collected funds on hand by which to pay its tax. Based on the foregoing, the company had available funds with which to pay the taxes it owed during the liability period, but it failed to do so, choosing to pay others instead. Based on the foregoing, appellant willfully failed to pay or cause the payment of the company's sales tax liabilities for the liability period and is thus personally liable as a responsible person for the company's sales tax liabilities for the liability period. As to appellant's request for relief from penalties and interest, as stated earlier, the department has removed the notice of determination finality payment from appellant's assessment. However, appellant has failed to show good cause for relief from appellant's penalties pertaining to the company's failure to file tax returns for the third and fourth quarter of 2008, the late payment penalties for the first and second quarter of 2009, and applicable interest. Revenue and Tax Code Section 6592 governs the standard for relief from both failure to file and failure to pay penalties. It allows for relief only where the failure to file or pay was, quote, due to reasonable cause and circumstances beyond the person's control and occurred notwithstanding the exercise of ordinary care in the absence of willful neglect, end quote. Here, appellant has not provided any reasons concerning either his failure to file the company's third and fourth quarter 2008 returns or for failing to pay the taxes for the first and second quarter of 2009 that would amount to a circumstance beyond his control. The evidence shows that appellant filed returns for the company prior to and subsequent to the third and fourth quarters of 2008. Therefore, the argument that appellant was unaware of his failure does not suffice as an event beyond his control. Moreover, to the extent that appellant argues that the downturn in the economy and or issues with the company's business income prevented him from filing and paying these taxes, this argument is unavailing since appellant collected sales tax reimbursement for the sales during these periods. Therefore, had appellant exercised ordinary care, those funds would have been set aside and remitted to the state. Accordingly, appellant has not provided a basis for relief under section 6592. As to appellant's request for relief from interest, appellant has alleged that delays in the settlement process impacted the amount of interest due. Revenue and Tax Code section 6593.5, subdivision A, does allow for relief of all or any part of the interest imposed where the failure to pay tax is due in whole or in part to an unreasonable error or delay by an employee of the department acting in his or her official capacity. However, subsection B of the statute requires that no significant aspect of the error or delay may be attributable to the taxpayer for relief to be granted. Here, there were no delays to that were attributed to the Department Settlement Bureau or to any other department employee. Appellant entered into settlement negotiations on 3 different occasions, and each time the parties were unable to reach a settlement agreement. It was appellant's requests that delayed the hearing in this matter because his requests to enter into settlement continuously attributed to the delays in this case proceeding. Therefore, he does not qualify for relief under section 6593.5. In conclusion, the evidence shows that appellant is liable pursuant to section 6829 of the Revenue and Tax Code because 1, the company terminated its business in 2009. 2, the company collected sales tax reimbursement. 3, appellant was responsible for the company's payment of sales and use tax. And 4, appellant's failure to pay was willful. Aside from the department's concession as to the notice of determination finality payment, appellant has failed to provide a basis for relief from the assessed penalties and interest. Therefore, we ask this panel to affirm the decision and recommendation in this matter. Thank you.
This is Judge Ridenour. Thank you, Ms. Daniels. Judge Brown, do you have any questions?
Thank you. This is Judge Brown. I do have a question for Cdtfa, and it pertains to the request for relief of interest. And I'll preface my question with the caveat that I'm not asking about anything that's confidential, because I know that settlement negotiations may be confidential, but I'm asking about the timeline. First, Ms. Daniels, can you tell us what are Cdtfa's standard timeframes for settlement negotiations, if there are any standard timeframes?
My understanding is it depends. And Jason, do you have a better idea as what the standard is to the settlement time?
This is Stephen Smith. I don't think that there are standard timelines for settlement negotiations.
This is Judge Brown. Thank you. Then I'll be more specific. Is there a standard time frame for processing a settlement agreement after a taxpayer has signed a settlement agreement with Cdtfa?
I don't know that there would be a standard time frame for that.
All right. This is Judge Brown again. Is there a reason why the Settlement Bureau, if you can tell me, is there a reason why the Settlement Bureau would need a taxpayer to sign a new settlement agreement after the taxpayer has already signed a settlement agreement?
We can't really answer the nuts and bolts of what happened between the settlement officer and.
And this is Judge Brown. As I'm saying, as I said, I'm not asking for anything confidential. So I'm asking if you know, I'm only asking for what you can tell me. I guess I would say, I guess I will ask, were there any unexplained absences of work on this file for, you know, for any of the time periods that we're looking at for relief of interest?
We can't really speak to anything beyond the time periods that it was in settlement. And I think that's set forth in the reply brief that we submitted to the office, to the panel a week or two ago.
Then that's all my questions for right now. Thank you.
This is Judge Reitauer. Thank you, Ms. Brown. Judge Brown. Judge Lambert, do you have any questions?
This is Judge Lambert. I don't have any questions. Thanks.
This is Judge Reitauer. I actually do have a question. I understand, again, settlement is a confidential process. I looked, and between the date that taxpayer submitted the sign, this is again to interest relief, between the date that the taxpayer signed and submitted the settlement agreement to the date that he received an email from the individual he was working with in the Settlement Bureau was 339 days, approximately 11 months and 4 days. And in response to interest abatement, Cdtfa brought up section 2B, no significant error or delays attributed to an act or failure to act by a taxpayer, which I understand there was some delay on that part of the taxpayer wanting, this was the second revision. After hearing back in November, there was some communication between Cdtfa and the taxpayer. However, in those 339 days, Cdtfa, would you say that any act, was there any failure or any, was there, would you say that 2B would be appropriate to say that between those 339 days would be applicable for that period?
We're not prepared to speak about what was happening within the Settlement Bureau during the time period between those two emails.
Thank you very much. Those are all the questions I have for Cdtfa. This is Judge Reitauer. Mr. Eichler, if you like, you may make a brief closing statement in response to Cdtfa's argument or further address any of the questions asked by the panel, but it is not required. Would you like to make a final statement?
Yeah, I would like to at least make a few comments to close, if I may.
Okay.
So I'm trying to digest all the things that Ms. Daniels presented, and again, this is an overwhelming amount of information, and again, that is what you do, and all the rules, regs, codes, this and that. It's not what I do, so sometimes understanding all that is not easy. But having said that, I do want to add to the information is that when I got a call, which I believe was in the latter part of 2009, about missing the quarter Q1 and Q2 at that time of 2009, that, you know, the turmoil was again so severe. But I was advised to report even if you could not pay. That it was most important to report the information as you knew it, And that was, again, the reason for putting those in. Otherwise, I might not have done those as well. Not to say that that's right, but I'm just saying because of that call and that conversation that I had with, I think it was still State Board of Equalization then, that's why I did those and got those got those in there. So trying to catch up, trying to get out of the mess. The other thing I heard a word of conscious in there about what is the taxpayer conscious that those were due? At the time, no. At the time of Q3, Q4, 2008, obviously even into 2009, because it took a phone call to say, oh, something is missing. There was no conscious ability to even, it was just, as I said, the economic duress and the financial duress were so incredibly bad, for lack of a better word. It wasn't even there. And then by the time this came around again, I'm trying to remember, I was called, I was asked to come talk. I did that willingly. I was trying to, again, be honest and have integrity and go through the steps with them as they saw it at the time up in San Francisco. I remember sitting there and doing that with 3 pairs of eyes, asking questions and looking at me. And here I am still in this financial mess. But I did it. I went in there and I'm trying to do the right thing. And again, and I will come back to that settlement agreement. I signed it. I did it. I was also told by not only the then legal counsel that I had, which cost me a fortune, which whatever. And a fortune to me, by the way, is not necessarily a huge sum of money. And I was also advised by, I think, at least 3 of the other representatives of the Settlement Bureau, if that's what it's called correctly, that even once you signed an agreement, it could take 6 to 12 months for it to be signed and returned and approved. So, I mean, November was still within that, or December, November, was still within that window as to what it had been told to me was, a period in which it could take for that to be approved and signed. And every time I asked many times I would ask questions of the person with whom I was speaking, and I either wouldn't get an answer, or I wouldn't get a direct answer, or I'd get some kind of answer like, oh, well, we can't tell you that because it's legal advice, when all I was asking for was, could you tell me what code, what section can I go look at to understand what I'm working with here? But I would always get the answer, sorry, we can't tell you that. And that to me is not transparency. And I know that that's the word that gets bantered around a fair amount within the Cdtfa and even then the State Board of Equalization world. And I'd like to think that I was doing the same thing. I was just trying to understand, and I still couldn't get questions answered. So I'm going to stop there because I want to be mindful of all your time. I know it is what it is, but I'm just going to leave it at that.
This is Judge Ridenour. Thank you, Mr. Eichler. I'm going to ask my co-panelists if they have any final questions of either party. Judge Brown, do you have any questions?
I don't have any more questions. Thank you.
Thank you. This is Judge Ridenour. Judge Lambert, do you have any questions?
This is Judge Lambert. Well, I guess I could ask Cdtfa, just, not talking about what happens in settlement, but, would it be typical to be leaving and entering settlement negotiations or entering settlement, 3 times? Is that typical or what?
I believe that it's uncommon. It would be initiated by the taxpayer.
Okay. Thanks. I think that's all the questions I have. Thank you.
This is Judge Ridenour. I just have a couple questions for you, Mr. Eichler, real quick. The The funds that you used during the liability period to pay the vendors, do you concede that you did use the available funds at the time to pay the vendors instead of paying your taxes?
At that time, I was getting calls from the vendors had already turned to collection. And the kinds of calls that I was getting, well, first of all, not having ever experienced those kinds of calls, were, again, go to that financial and economic duress. They were threatening, they were harsh, they were abrasive, they were abusive, and they were as if your life depended on it, was the way, that they were being, presented to me. I didn't have any clue. I mean, this is shameful, and I hate to admit this. I had no clue what money was what. In other words, if it was there and they were saying, I need something, can you pay this? Can you do it right now? Can you wire it? Can you, whatever. It was reactionary and not conscious. So to answer your question, obviously, truthfully, again, hindsight's 2020. Clearly, that the money not having been segregated between different accounts holding, funds for different reasons, which, believe me, I do now. I mean, I wish I could go on a train on a, it's kind of like, I wish I could go train people now on how not to do things, or how to do things, of course, by virtue of having not done things. It's clearly, was done not well. So I have to answer your question honestly. Yes, I mean, I have to believe, again, sitting here, what, 13 years later, that because the money was all there, that some of it had to be. I can't disingenuously say no.
Eichler, I understand it was a really hard period, and I appreciate your honesty. And, obviously the panel and I still need to discuss this, and do know, however we decide does not take into account, does take into account, like, we understand. And
I do.
Please know that. We obviously have not discussed this, and we have no idea how we will decide, but please know. Okay. I would again want to thank everyone for participating today. If there's nothing further, I am now concluding the hearing. At this point, the case is now closed and the case is now submitted. The judges will meet and decide your case later on, and we will issue a written opinion of our decision with 100 days after the record is closed from today. Today's hearing in the appeal of Stephen Eichler is now adjourned, and the next hearing will resume at about 2:05, 2:10. All right. Thank you, everybody, and have a good one.
Thank you.
Thank you.
Thank you.